Most employees know that they can take legal action if they become a victim of retaliation at work. But what most workers don't know is that retaliation cases involving safety issues can be some of the biggest cases in employment law. When a company fires an employee shortly after he reported a legitimate safety concern, juries are eager to smack that company with a big verdict. This video is going to examine what unlawful retaliation looks like in the context of safety and OSHA. I will explain how you should react if you reported a safety issue and you're now getting blowback from management. And finally, I will detail how much money you can win if you have a good case. So if you want to peek behind the legal curtain, keep watching. My name is Branigan Robertson, and I'm an employment lawyer. This video is part 3 in a 4-part series called Workplace Safety for Employees. In the first video, I detailed your rights to a safe working environment and the laws that are there to protect employees. The second video was all about the best ways to report an unsafe work environment. This video is about what unlawful retaliation looks like and the money that you could win in a lawsuit. And the final video is what you should do if you get hurt on the job and the money that you could get for the time that you have to spend away recovering. But before we get into the details of today's video, I need to discuss 3 very quick things. First is a question. Have you ever seen a company retaliate against somebody? If so, please tell us your story in the comment section down below. Responding to the horror stories that people post on my videos is one of my favorite parts of the job. 2. I have a license to practice law in California, but I'm making this video for all workers across the country. This video covers some basics, but it should not be taken as legal advice for your situation. The retaliation laws differ from state to state. More importantly, I don't know you or anything about your situation. You should never take what is said on an internet video as legal advice. If you need legal advice, call a lawyer in your state. 3. If you are in California, please feel free to call me for a free consultation if you think I've earned your phone call. But let me be clear about this. The free consultation process at my office is primarily for California workers who got fired from their job and they believe they have a case for retaliation, discrimination, harassment, wrongful termination, or something serious like that. The consultation process is not for giving out free legal advice and answering everybody's quick legal questions. Big picture, okay? Intuitively, most of you know what retaliation is, right? In the context of employment, usually this is where your boss or manager is punishing you because you first reported that they were doing something shady or wrong to management. Right, but it might surprise you that not all retaliation at work is unlawful. Here is something that I tell a lot of people. There's a significant difference between things that are unfair at work and things that are unlawful at work. While all retaliation is unfair, not all retaliation is unlawful. And I further explained this distinction in a video I made a few years ago called Workplace Retaliation Law. That video discusses all aspects of retaliation law, and I'll link to that video in the description below. But for the purposes of this video, which is all about safety, let me say this. Generally, it is unlawful for your employer to fire you because you reported some kind of safety issue or violation to your boss, HR, OSHA, or some other regulatory agency that has oversight over some aspect of safety at your job. And there are a ton of laws that back this up. There is an extensive list of safety retaliation laws in force across this great country. And I'm going to cover the most important ones in this video. And I'll leave links in the description below to OSHA documents that go into greater depth and explain more of the laws. But let's first cover the big and broad anti-retaliation laws. Okay, number 1. Section 11C of the Occupational Safety and Health Act, OSHA, right? This is the main anti-retaliation law under OSHA. This is a federal law, and it applies to all employees in all states. It says that employees are protected from retaliation for filing a safety or health complaint with OSHA, the agency, or with their employer. Number 2, California Labor Code Section 6310. This is the main anti-retaliation law in force in California for safety-related complaints. It essentially says the same thing as Section 11C, but it's better because California law is generally more favorable for employees than its federal counterparts. Number 3, California has an even more powerful statute, Labor Code Section 1102.5, subsection A. That law says that it's unlawful for an employer to retaliate against an employee for reporting safety violations to a supervisor at work or a government agency like Cal-OSHA, which is the California version of OSHA. Number 4, California Labor Code Section 1102.5, subsection C. This law goes even further and says a company is not allowed to retaliate against an employee who refuses to take part in an activity that violates any law or regulation. So, if your employer asks you to do something that is unsafe and violates some OSHA regulation and you refuse, they are not allowed to fire you. I wouldn't be surprised if many other states have a law similar to that. Number 5. California Labor Code Section 132A. This law says that an employer is not allowed to retaliate against an employee for filing a workers' compensation claim because they got hurt on the job. And we will cover that in much more detail in the 4th video, so stay tuned. Next, let's examine some specific anti-retaliation laws that exist across the country. Now, these specific statutes apply to specific industries or activities. And we'll go through them one by one, and at the end I'll give you a place where you can go find out more detail on each one of these specific laws. But I think this is really important that we at least talk about all the different federal laws that apply to these industries. So if you work in a company and they spill a bunch of asbestos all over the place and you complain about it, you're protected. If you work in the shipping industry or you work around shipping containers, safety issue, report it. Trucking industry, water treatment industry, water pollution safety, big deal. Industrial chemicals, solid waste like waste treatment plants, obviously is very important that we deal with that appropriately so the employees are protected from safety related complaints. Air quality, air pollution, massive environmental pollutants like oil spills, lead releases, the nuclear industry, the airline industry, securities fraud, so shareholders get accurate information. If you work at a company that's publishing information about publicly traded companies, that stuff must be accurate, and if it's not and somebody complains about it, you're protected from retaliation. The pipeline industry, railroad industry, public transportation, consumer products need to be safe for their customers. Patient safety, this is a big deal, especially in California. If you work in the healthcare industry and you see something that is not safe for your patients and you report it, you're protected from violation. The Affordable Care Act, the fishing industry, seamen are also protected if they report things to the Coast Guard. The consumer financial industry, like the Dodd-Frank Act, which increased protections for consumers like you and me when we take out debt instruments like mortgages, credit cards, and other financial stuff. Food safety, obviously the FDA has anti-retaliation provisions. So if you work in the manufacture or the production of food and you report something that is unsafe, they are not allowed to retaliate against you. Motor vehicle, if you work in a car company and you know there's a defect and you report it, you are protected. And taxpayer fraud, right? If you work at a company and you know that your boss is not reporting, not paying his taxes, and you complain about that, you are protected. Now, I'm going to leave a link in the description below to an OSHA whistleblower protection document that is published, and it looks like a spreadsheet, and it has every single one of these laws in it and a lot more details, not only the citation but the basic story of what each law does. So if one of these industries applies to you and you're somewhere across the country, take a look at that document because it'll show you what laws protect you. Next, let's take just a minute to look at what retaliation looks like in the real world. In the last video, I explained that if you see something that's unsafe at work, I generally recommend that you report it. And I explained how to make this report in order to minimize the chances that your employer will start doing some of these things to you or retaliating against you. And if you haven't seen that video, I strongly recommend that you watch it after you finish this one. Now let's say that you reported a safety issue and now your boss is upset with you. What does retaliation actually look like? Well, it can be many things. First, like being written up for something that is completely untrue or bogus, or being put on a performance improvement plan suddenly after 5 stellar years of job performance. Now you're being under the eyeball, or being demoted, or getting a pay cut, or being denied a bonus that you earned, or being removed from the good shift and being put on a less preferable shift, receiving verbal lashings from your boss or snide remarks, being lied about by other people to HR, being set up to fail, this one's so common, or, and most obviously, right, is being terminated. If any of these things are happening to you because you reported a safety issue first, what should you do about it? Well, if you're still employed, I generally don't recommend that you immediately pick up the phone and call a lawyer like me. Most lawyers are unable to help people while they're still employed for a whole bunch of reasons that are too complicated and time-consuming to explain in this video. But if you're still employed, generally, I recommend that you do what I recommended before. You submit an appropriate complaint in writing to HR saying that you are being targeted because you made a protected safety complaint. While doing this is unlikely to stop the retaliation. In fact, in some cases, it's going to make all this a whole lot worse. So why would I recommend that you do it? Well, for a legal reason. Because it'll be very helpful in your legal case down the road should they ultimately fire you. Employment cases get so much better and so much bigger if the jury sees that my client tried to get the help of HR, but HR ignored them, ignored their cries for help, and aided and abetted the retaliation just to appease management. Juries hate that. But beyond a written complaint, I also recommend that you watch a video I made a few years ago called How to Prove Retaliation. I'll leave a link in the description below. That video goes into more detail than I have time for here. But if the retaliation culminates in your termination, you getting fired, that is the right time to start reaching out to a lawyer in your state. Next, we are going to discuss how much money your retaliation case is worth if you got terminated. The honest answer here is that it depends, but I'll briefly explain the general framework of how damages work in safety cases so you can start to get a rough idea. Damages in retaliation cases come in 4 different forms: economic damages, emotional distress, punitive damages, which everybody's heard about, and attorney's fees. Let's break those down one by one. First and foremost, economic damages. I think these are the most important kind of damage, right? Economic damages are your lost wages, your lost bonuses and benefits that you would have had and you would have earned had you not been fired. So if you were making $100,000 a year and then you got fired after reporting a safety issue, you're not getting paid that $100K anymore. That is a tangible economic loss that we can measure. But that is not the end of the story. Let's say you got fired, but then 6 months later you found a new job. The amount you are earning at the new job affects your damages in the lawsuit. So if your new job earns only $50,000, well, there's a $50,000 differential that adds up over time and increases the value of your case. But that is still not the end of the story. If you get fired, file your case, and then just sit around watching cat videos all day on the internet while your lawyer pursues your case, the jury is not going to award you economic damages because you made no effort to look for a new job. The legal system does not reward laziness. And at the end of the day, the jury will ultimately make the decision how much money you will get. That is why no lawyer can honestly tell you how much your case will settle for or how much it's worth, because the jury decides, and juries are not always predictable. Next, emotional distress. The law allows you to recover for the emotional harm caused by the retaliation. This is for the pain and the suffering that you go through after getting fired unlawfully. While this is obviously much more difficult to measure or predict, this is usually a large component of your case. In some cases, juries will award way more money for your emotional harm than for your lost wages. And in other cases, juries won't believe that you were harmed all that bad, or they won't like you and they'll only award you a small token amount. It really helps prove that you were harmed if after getting fired, you seek out professional help, such as going to therapy or seeing a psychiatrist. And if you're paying attention, you can see that this is very hard to predict early on what your emotional distress damages are worth. But after a lot of discovery, meaning the time in which the case has gone on and the lawyers have done a lot of work, usually we can get an idea of how much we can demand in settlement discussions. Next, punitive damages. Everybody's heard about punitive damages, right? These are the monetary damages juries will award employees in order to punish the company for acting in such a despicable way. These damages are only awarded when you can prove that the company acted with malice, oppression, or fraud, which is a much higher burden of proof. The goal is to deter the company from acting like that again in the future. But punitive damages can become very large very fast. And it's not uncommon to hear about a plaintiff being awarded like $100,000 or $300,000 in economic and emotional distress damages, and then being awarded over $1 million in punitive damages. Those verdicts tell the world that the company acted very bad in that case. And finally, attorney's fees. Under some of the laws that we talked about earlier, you can also win attorney's fees. What this means is that if you win your retaliation lawsuit under one of the applicable statutes that permits recovery of fees, your lawyer can recover an hourly rate for all the time they spent working on the case. And as you might imagine, this can be a very big number at the end of the day. While this does not directly benefit you, the client, as attorney fees go to the attorneys, having these damages on the table usually helps push your case into settlement discussions. What do I mean? Well, if the company is not only looking at the prospect of paying you a bunch of money if they lose in economic, emotional, and punitive damages, but they're also looking at paying your lawyer 6 to 7 figures if they lose, they are much more likely to come to the bargaining table before trial and settle to mitigate that risk. And settlement can benefit you because you avoid the risk and stress of trial and you get a guaranteed amount of money. Well, what if you didn't get fired? What if you quit your job under one of these circumstances? Well, I made an entire video on this subject called How Much Money Are Retaliation Lawsuits Worth? I examined the value of cases for people who got fired, who quit, and who are still working. So if you want a deeper dive into case value, I recommend you watch that video. Link is below. So, how much are these cases worth? Well, if you paid attention to this video, you should know why it's very difficult to predict. They can be worth nothing and they can be worth millions. It all depends. But I like safety cases and I like them a lot. I think these retaliation cases can be worth a lot of money because juries absolutely hate it when companies treat their employees like discardable tools, right? Juries hate it when companies treat their employees like garbage. Juries hate it when HR tries to cover up retaliatory behavior by firing an employee. And in my opinion, if you are fired after you report a legitimate safety complaint, I strongly urge you to pick up the phone and call a lawyer in your state. If you are in California, please don't hesitate to pick up the phone and call my office for a free consultation if you feel like I've earned your phone call. But please remember, I'm a California lawyer. Please don't call me if you worked in a different state. If you worked in Texas, you need to call a Texas lawyer, not California. Also, please be respectful of our time. The free consultation process at my office is for California employees who believe they got fired unlawfully. It is not for giving free legal advice to everybody who's still employed. It is extremely time-consuming to give legal advice, and my time, unfortunately, is limited. If you have any general questions about what I've said in this video, please ask them in the comment section down below. If you know anybody who should watch and understand the concepts in this video, please share the video with them. And please, if you like this kind of content, subscribe to my channel because I plan on making a lot more videos about employee rights. I hope this was helpful. Take care.